Hello and welcome back to Attorney Paz's Rants of a Criminal Defense Attorney. This week I'm in my office. I had an office day, which is exceedingly rare. I'm usually in court most days. But this week I want to talk about conditions of release. So once you're arrested and you go to court for your arraignment, the judge is going to put conditions of release on you. And in addition to what you normally consider conditions of release, i.e. bond, you have to pay money to get out of court, there are also non-financial conditions of release that the judge can put on you. And to be honest, anything and everything under the sun seems to be fair game. So like, for example, in a family case, a condition of your release will also include to abide by a protective order. If you violate the protective order, in addition to being arrested for violating the protective order, you can also be charged with violating the conditions of your release, and also so your bond then would be increased. Additionally, what I have seen some courts do is say you pick up a domestic and your child is involved somehow in the case. DCF now gets called, DCF starts their investigation. Whereas the statutes and the Constitution would normally provide you with the right not to cooperate with DCF. You then go to criminal court, and criminal court then says, well, as a condition of your release, I'm making it mandatory for you to cooperate with DCF. So that opens up a whole nother can of worms. In lately, the immediate cause for this rant is they can also stick an ankle bracelet on you and say, well, you could either have, you could have a curfew, you can only leave your house between this hour and this hour, or you can have complete home confinement. You can't leave your house at all except for court and medical purposes. Now, in this particular situation that I'm talking about, this guy has been on house arrest, completely can't leave his home for months, since April. Now, imagine you are unable to go to work, go to school, go buy groceries, pick up your children from school. And that's what's happening to this man. And essentially, the court system is now making him homeless. So because he can't go to work, he doesn't have any money, he can't pay his bills, he's getting evicted. Every time I go to court, the court just basically shrugs his shoulders and says, well, I'm not modifying anything. If he can't, if he doesn't have a place where he can stay on the outside, I can provide him with housing on the inside. So, there's very minimal ways for us to review these conditions of release. The trial court has a lot of leeway and authority in these cases because they're considered to have to be closer to the case and have the best knowledge on what is needed to ensure the presence of the defendant in court and also protect the community. But there is a direct appeal process by which the appellate court can review your conditions of release. But to be perfectly honest, it's not a full-out appeal, it's just a review, and most of those reviews don't go anywhere. I did an appeal of one last year and it didn't go anywhere. So that's my rant for the day. If you get picked up, there are motions to modify the conditions of your release. You could have a full-out hearing on it. One of the hearings, if you get a full no contact protective order kicking you out of your house, you can file for something called a Fernando A hearing. You're entitled to a complete and full evidentiary hearing about whether the state can bear the burden of showing that this level of protective order is necessary for the protection of the complainant. And you should definitely insist on these types of hearings. You should talk to a lawyer about it, but be prepared when you go to court for the judge to not only put bond on you, but also put on you non-financial conditions of release. So that's my rant for the day. Give me a call or email me, Brittany@roweneattorneys.com. And as always, take care, don't get arrested, and see you soon.